Police officer, have a search warrant for your house.
Before police can come into your home, they must have a good reason. It says so in the Constitution, specifically in the Fourth Amendment. The law that controls searches and seizures is perhaps the most volatile in all of constitutional law. It's called criminal procedure, and it changes just about every time the Supreme Court meets. The Constitution protects you against unreasonable police searches by requiring what is known as probable cause. The police must be reasonably certain you possess criminal evidence.
The whole thing is an assumption that people have what we would now today call a fundamental right of privacy, particularly in their homes, and that police in particular and other governmental agents really should not disturb the citizen unnecessarily.
Professor Frederick Lederer is an expert in criminal procedure. He teaches it at the law school at William & Mary.
On one side, society has a right to find evidence of crime and contraband like drugs. The problem is that we often forget that when the police arrive at your doorstep, and even if it is only one officer, and often, of course, it's more than that, officers in uniform, often armed, on your doorstep are a truly upsetting event to most.
That is why there are rules and safeguards. Defense attorney Peter Decker.
Well, I think that is probably the most protected of all of the constitutional rights by the Supreme Court.
Police must get official written permission to do a search. They must convince a magistrate, a judge, to issue that permission. It's called the search warrant. These pictures are of an actual search being conducted. We are in a private residence in Thorogood. While under some circumstances searches can be done without a warrant, police had a warrant for this one. Here's how it worked in Virginia Beach's 3rd Precinct during a month-long drug sweep. Sergeant Ernie Marrow ran the operation.
Well, the men would go out each day, even on their days off, for a couple of hours, walk around apartment complexes, and when they would spot a marijuana plant, they would note the address and the apartment number, and when they came in that night, they would type a search warrant affidavit for that particular address.
The warrant allows the police to come into your house and search. It lists the suspected crime and the probable cause that first tipped them off to it. Once in the house, police can look for anything named on the warrant, and sometimes more than that.
If they see something else while they're in the process of searching for whatever it is that the warrant permitted them to search for, such as drugs, then they may seize that material as long as it's something like burglary tools, drugs, or evidence in a case.
If they happen to see something else while they're reasonably looking for that contraband as described in the search warrant, and then that comes within the plain view doctrine. They've found something else and they can certainly use it.
Here's how it works.
Marijuana can be readily hid anywhere. So consequently, that search warrant affidavit gives you the right to search that entire house.
Now remember, the key word is reasonable.
You can't search a drawer or a pair of socks for a television set because it won't fit in there. In other words, what I'm saying is, if you type a search warrant for an elephant, you can't look in the dresser drawer for it.
Next, we'll show you just how all this law worked in practice, in your homes and somewhere else. Tomorrow, we'll look into searches and seizures in your car.
Good afternoon, sir. Could I see your driver's license and registration, please?
Howard Jaffe, The Daily News.